How many tales of driving loopholes have you been spun in your life? Well, here to help bust some myths is Emma Patterson, Principal Solicitor at Patterson Law. Emma, good evening.
Good evening, Mark. Nice to speak to you.
Likewise. Well, there are many of these stories that do the rounds. I'm going to throw one or two your way, if I may. And if they're complete nonsense, please do bust them for me. The first one is if you get something through the post that says your car, for example, was doing, 60 in a 50-mile-an-hour limit, you decide not to identify who was driving because that will be a breach of your human rights.
Mm-hmm.
If you don't want to say, is that okay? Is that a suitable defence?
It's an argument that was raised repeatedly, probably 10, 15 years ago now, where people said that it was an infringement of something called the doctrine against self-incrimination, because there's a basic premise in English law that you shouldn't be forced to incriminate yourself. That's why we have a right to silence in the more serious criminal cases, where you can say, I remain silent in interview. But that argument in road traffic cases, specifically in relation to the request for driver information that comes through when the police aren't sure who was driving at the time, it's been to the Human Rights Court repeatedly, and every potential argument has been exhausted. And the Human Rights Court have said that it's absolutely proportionate. This power to compel people to provide that particular element of the evidence in the case, the identity of the driver, is proportionate to the need to maintain road safety. But still, I probably speak to 20, 30 people a day, and I still get a significant number of people who will come and say, you can't force me to compel me to provide this information with threat of punishment for not providing it. But the reality is the European Court of Human Rights have said that the police can.
Well, thank you for busting that one. And then here's another one. If you you buy a new car and you haven't registered yet, but then something goes wrong, it is okay for you to have driven it on your old car insurance policy. You won't be driving without insurance at that point. Is that right?
No insurance cases are interesting, actually, because there's an absolute overlap between civil litigation, which is a contract between you and the insurance company where they'll indemnify you against an accident for X amount of money, so it's an exchange of promises. And then you've got the criminal side of things where you get accused of driving without insurance. So you always have to look at the specific terms of an insurance contract to decide whether or not you've committed a criminal offence of driving without insurance. And it's always worth looking at the individual terms and conditions of that policy. But the basic premise seems to be that insurance policies that cover you to drive another motor vehicle stipulate that that motor vehicle has to belong to another person. And the moment you pay your money, from a civil point of view, it belongs to you. So your insurance company would not indemnify you if you had an accident in a vehicle that you'd purchased, that you'd bought. Even though the V5, the registered keeper details, might not yet be in your name. It's interesting because the V5 actually stipulates, if you look on the document, it says being the keeper of the vehicle is not proof of ownership. So you can be the V5 keeper and not actually own the vehicle, and vice versa. So police officers will say to you, the moment you've paid that money, it belongs to you, therefore your insurance, which indemnifies you to drive a vehicle belonging to another person, won't apply. So the moment you pay over your money, you've got to have insurance for that specific vehicle.
Do it straight away. Well, that's really, really good to know. Now, this just came up today, actually. We've got a story just after 8 o'clock on the show about a woman who delivered her sister's baby in the car whilst they were being driven to the hospital. And she was told by the people at the maternity unit that it was okay that they'd run a load of red lights to get there because they would never be prosecuted by the police if someone in the car was in labour. Is that true?
You'd hope so. You'd absolutely hope so. Running red lights is what's called a strict liability offence. So the police don't need to prove that you meant to do it or that you had a guilty mind whilst you were doing it. It's a very factual offence. You drive a motor vehicle and a part of that vehicle proceeds beyond the stop line whilst the lights are on amber or red. Most people don't know that going through on amber is an offence as well. So if any part of the vehicle proceeds beyond the stop line and it's on amber or red, then technically you're guilty. But the police have the same discretion in road traffic offences as they do in any other kind of offence. They have a duty to look at whether there's been any criminality, whether there's any public interest. I always like to think of it, if it was on the front page of the news tomorrow that the police had got these cases, would there be a riot in the street? Would there be a public outcry? And I think the sentiment would be, that sounds fair enough. And if the sentiment is, that sounds fair enough, then I tend to trust the police will do the right thing in that kind of case. So technically there's an offence. There's definitely something called a special reasons argument where you could probably avoid the points on the basis that it was an emergency. Okay, but strictly speaking, there would be an offence if the vehicle went past the stop line whilst the lights were on red or amber.
That is interesting. Are there any actual loopholes? Because, you know, we do read in the papers all the time about special loopholes that only very, very important solicitors know about, and they can always make these work for you. Do they exist?
It's the bane of my life. You know, like I said, I speak to 20, 30 people probably a day, and so many people come to me, and I think I'm a very good motoring lawyer. This is all I do day in, day out, and so many people come to me and say, I've been told by X, I've been told by Y that they've never lost one of these cases because they have a formula, you know, some kind of loophole argument that always works. The reality is every case is unique. The police's job is to apply the law properly, and the lawyer's job is to see whether or not they've done that, and as a result of them perhaps not doing their jobs properly or not applying law correctly, whether there's a potential defence. We had a case recently which would probably be perceived as a loophole-style argument. It was a dangerous driving allegation against a professional driver, but there was no accident, so there was a need to serve something called a notice of intended prosecution. That has to be served within 14 days of the date of the offence for certain offences, and in dangerous driving that applies if there's been no accident. And the police had failed to do that. So that was dropped purely on the technical argument that that notice had not been served. Section 1 Road Traffic Offenders Act says you shall not be convicted if the police haven't applied that rule. So a lot of people from the outside looking in would feel that the actual case, the actual standard of driving was never tested. It was never assessed by the court, and that the police were forced and the prosecution were forced to drop it because of a failure to apply a rule. And in that kind of case, I suppose that's the type of scenario where people perceive it as a loophole. I don't agree. I think it's just applying the law correctly. The government have imposed the law. They've come up with these statutes, and my job is to make sure that they're applied properly.
Really interesting to talk to you. Many, many thanks, Emma. Emma Patterson is Principal Solicitor at Patterson Law.